So what happens if you trade with somebody and then afterwards you find out that you didn't have an ISDA Master Agreement signed and in place before the trade happened? Obviously, best practices is to have these agreements signed in place, but things happen from time to time, and this is not that unusual. And normally where you see this is you're used to trading with one office and then you trade with another office. And for instance, if you trade with a bank in Germany and then you do a trade with somebody in their London office, and then you find out that the ISDA agreement that you signed with them, so you do a trade with them, and then afterwards you find out that the ISDA agreement that you had signed only covers trades with their head office. It doesn't cover any of their other offices. So you can fix that. If they're amenable, you can amend the agreement and have a multi-branch agreement. And if they don't want to do that, and you've already done the trade, which is legally enforceable, then you'll have what's called a vanilla ISDA. So what is a vanilla ISDA? So if you look at the confirmation that you sent or were sent, it has enough terms to be considered a meeting of the minds under New York law, in my opinion, and it references the ISDA Master Agreement. So I mentioned before you have the ISDA Master Agreement, which is a boilerplate thing, and then it's got some elections and things that you can negotiate, and then you put that in the schedule, and then when you do the actual trades, you have the confirmation. So if you don't have an ISDA master in place, then you don't have the schedule, obviously, and this confirmation refers to the ISDA master and incorporates it. So you'll have the ISDA master with no elections in the schedule and no customization and the confirm. So you're kind of missing a lot, but it is still legally enforceable. And let's look at an example. So I got this from the SEC's website. This is during the Great Financial Crisis, and this is from Wachovia. And you'll see that it says it confirms the transaction between Wachovia and their counterparty. And the confirmation, like all confirmations, says it's subject to the ISDA Master Agreement. So even if you didn't have an ISDA master and the schedule with the changes and elections in it, this confirmation references the ISDA Master Agreement. So the terms of the ISDA Master would apply, and therefore you'd have what they call a vanilla ISDA. So best practice is to have a signed agreement in place or to negotiate one as quickly as possible, because if you just have the master, you don't have the schedule. The master is boilerplate. It doesn't set out the specified entities, the threshold amount, things like cross default, automatic early termination, the tax representations, what documents you need to deliver, who the counterparties are, things like that. So you'd want to have that, but if you don't, the ISDA vanilla is legally enforceable. And I know this is kind of hard to read, so here's another example. This is from Morgan Stanley in 2002. Sorry, Goldman Sachs in 2002. And this is the confirm, and it incorporates by reference not only the ISDA master, but the ISDA definitions, which are helpful. And even if you didn't have an ISDA in place, this confirmation is enough, and it incorporates by reference the ISDA Master Agreement and the ISDA Credit Support Annex. So if you did this trade with the wrong counterparty, you would have this vanilla ISDA, and the provisions of the ISDA Master would remain until you can negotiate the schedule and have it signed. So as I said, that's the most common scenario where you're used to dealing with the main office of one entity, and then you do a trade with an overseas office of theirs, and they say that doesn't count because our ISDA master, you can only trade with their head office. There could be other instances when you want to trade with somebody and you don't have a ISDA master in place, so you do the trade and then negotiate in good faith after to get all the terms hammered out. And when would that be? If you have to get a trade done quickly. So let's say that you have a hedge in place with a counterparty and the counterparty goes bankrupt, and you don't know if you're going to get paid on that or not, but you need to replace that hedge right away. And so you find somebody who wants to take the other side of that, but you don't have a ISDA master negotiated. So you do the trade, and then you have your legal people deal with their legal people and work out a ISDA master and have the schedule done. But in the meantime, if a problem arises, ISDA vanilla. So the confirmation which references the ISDA Master, will incorporate the ISDA Master until you can get one signed and have the schedule with the elections and terms that you've negotiated apply. But if you don't get that schedule in place, then with the confirm and the ISDA Master, it's not ideal, but it's legally enforceable. And that's how that would work. So if you have any questions about this, just leave them in the comments. And if you want to see more stuff like this, just like and subscribe to the channel so you'll see future videos when I put these up. And I'm going to put more of these videos in the ISDA playlist so you guys can refer to it. Since I'm a lawyer, here's the disclaimer. I'm a lawyer, but I'm not your lawyer. Anything you see here is for educational and informational purposes only, and it's not to be relied on. If you have a specific legal question, talk to your own lawyer. Nothing that I say here or write here is intended to create an attorney-client relationship. I'm not your lawyer now, nor in the future. And these opinions are my own and don't represent the opinions of my past employers or future employers. Have a great day, everyone.